Hello, everybody. Good afternoon, and thank you for joining us. My name is Lexi Herndon. I'm the Director of Communications and Business Operations at the Environmental Finance Center at the School of Government. On behalf of our team, I'd like to welcome you to our webinar on Water Utility Authority to charge impact fees and other upfront fees. I will be providing some technical support for today's session. Please take a moment to observe your GoToWebinar control panel. Most of the functions are self-explanatory, but I'd like to draw your attention to the questions section on your control panel. During today's session, you all will be kept on mute to ensure audio quality and minimize background noise. Should you have a question, please type it into the GoToWebinar question dialog box. We will be holding all the questions until the end of the webinar to ensure that we end on time. We have over 250 registrants for this webinar today, so we'll try to answer as many of your questions as we can. Please note that this webinar is being recorded and that all questions are a matter of public record. We will share the presentation slides with you as well as the webinar recording. If we are not able to answer your question due to time constraints, we will follow up with you after the webinar to address your question. Finally, after the webinar, you will be sent a short survey to provide feedback on the webinar today. Thank you in advance for providing your feedback. This will help us improve future training sessions. And we're excited to have so many of you joining us today from across the state. Welcome. And now I'd like to introduce our two expert School of Government colleagues, Jeff Hughes, the Director of the EFC, and Kara Millonzi, Professor of Public Law and Government. Take it away.
Thank you, Lexi. This is Jeff Hughes, and I'm going to start with some general overviews, and then my colleague, Kara Millonzi, is going to jump into some of the legal analysis. Next slide, please. This is a quick slide that shows the Environmental Finance Center. Hopefully some of you have worked with us in the past. I just want to point out that this is a program within the School of Government that focuses specifically on issues that we're going to discuss today. That is challenges related to financing environmental services and programs. Today we'll cover a little bit about an overview of current practices in the world of upfront fees. We'll talk quite a bit about the case and repercussions of the recent court case that dealt with impact fees. We'll talk a little bit about recommendations, green, that we know you should be doing, red, that we know you shouldn't be doing, and yellow, which we are still trying to figure out, but we have some recommendations. We'll finish up with some time for discussion and questions. We will have a few polls during the day just to get an idea of current understanding and some of the perceptions out there related to fees. The first one is pretty basic. Given some of the recent developments, we'd just like to get a pulse of the audience. How would you rate your understanding of current utility authority to establish upfront fees? And I'm using that term upfront fees to mean impact fees, capacity fees, tap fees, pretty much any type of fee other than the recurring fees that you charge. So please take a minute to answer it with your keyboard. Okay, we'll close that poll down. Okay, it looks like, just quickly looking at the poll results, that most of you are in the middle. And we have a few that are fairly confident with high understanding and a few with low understanding. Thanks a lot for that. We'll keep going. What best describes your role? Are you with utility management? That might be a utility director or a utility finance professional. Are you a professional advisor? Are you with a general government? Are you a city attorney, a county attorney, or are you something else?
Give folks just a few more minutes, seconds. All right.
Okay. All right, a diverse representation of professional responsibilities as well. Okay, keep going. And finally, this question actually, as you'll see in a minute, does pertain to what we're going to share with you. What type of utility do you all work with? What best describes your utility? And we're asking this because, as probably most of you know, utilities in North Carolina have different authorities, and some of the recent developments in impact fees impact certain types of utilities more than others. So we just like to know who's on the phone. Okay. Okay, it looks like 3/4 of our participants identify themselves with a city-owned utility, 12% with a county-owned utility, and then a few with some other types of utilities. Okay. And I think you'll see in a minute that most of our content is oriented to you. So glad to have you in the audience. Next slide. Just a few more slides of background information, and then we'll jump right to the legal analysis. We did want to point out, in the world of public enterprise services, utility fees, utility services, it's good to keep in mind what utilities across North Carolina actually provide. And I think sometimes we only focus on the treated water and the treatment of wastewater. That is to say that a utility is providing gallons of water or treating gallons of wastewater. But we do see other important products that a utility provides. Guaranteed capacity is an important one and relates to some of what we're going to talk about today. This is, in some cases, hard for people to wrap their head around, but when you put it in terms of many customers and many developers need to have guaranteed capacity before they can actually do their project, the idea of a utility providing capacity, aside from just treating wastewater or treating water, is important. So we do want to bring to your attention that selling capacity, allocating capacity is a very important function of utilities in North Carolina. And then, of course, there's many other services that are provided: public health, economic development, environmental protection. Just want to start with this slide because so often in pricing water, we think of gallons of water, and it's more complicated than that. I'm going to talk a little bit about what we see as far as current practices in North Carolina. This is related and informed by several studies that we've done over the years. The first thing I want to point out is there's quite a bit of diversity in terms and labels for different fees in North Carolina, and we'll discuss that again later in the webinar. There's a variety of methods for determining the cost of a particular fee. In other words, how much does the utility need? And then there's a subset of that question in how do you allocate what you collect or the cost that you're trying to collect between different customers. All of these different aspects of fee setting in North Carolina vary quite a bit across the state. We have utilities that use meter size to determine what a customer pays, and we have utilities that use square footage, anticipated use, and other indicators. There's a variety of combinations of fees. If you go to 2 or 3 different utilities and ask them what fees they charge, in some cases they may charge 3 or 4 separate upfront fees, and in other cases they may just charge one upfront fee, and all of the different fees will have different labels. The reason for all that variation, from what we've found in our research, is that local conditions and circumstances vary so much across the state that local utilities normally have rationale for the way they proceed, and the statutes in general provide a lot of flexibility in this area. The last thing I'll say is many of you will have had your fees set by internal staff. Some of you will have used outside advisors Again, there's no one standard in North Carolina. The key aspects of fees to consider before we even get into the meat of it is how your fees are presented to the outside world. And in our research, what we've noticed is that there are many different ways of presenting fees. You may have a work team or a workforce or a work group develop a need for a fee. Then you might elaborate the need in an official ordinance. You might have your own staff or a consultant use the wording in the ordinance to calculate the fees. But then on your website, you may have a general narrative about why the fees are needed, and then you might have a title. In some cases, with the communities we've worked with, all 5 of these aspects line up and are consistent. In other cases, we've noticed there's discrepancies between what it might say in an ordinance and how the fees are calculated, or how the fees are communicated to the public. So be aware of this as you work on your fee processes. For those of you interested in the status of fees across the state, I urge folks to take a look at a report that we did a little over a year ago that actually looks at all of the topics I've been discussing. We look at what fees are called, how they're calculated. The one thing I want to point out in the webinar, because I think it's very important, is that in terms of sheer magnitude of fees in North Carolina, most of the fees that we've seen over the years, and these are combined fees, these are fees with lots of different titles all wrapped together. What we asked was, what does a residential customer walking into your door have to pay to get service? And what we see is the vast majority of utilities that have these fees are in the $1,000 to $4,000 range, which is important because there are many states that we've worked in across the country where the average fee size is much, much larger. So in North Carolina, we would characterize North Carolina as a relatively low-cost fee state. For example, Colorado, Virginia, some of the western states we've worked in, we see fees where the median fee is $10,000. With that general background, I'm going to turn it over to my colleague, Kara, that will jump into some of the legal aspects of fees.
All right, so hi everyone. A couple of disclaimers before we jump into the legal analysis. First, and this is a really important one, although we're going to be able to identify some things that we know for certain about your fee authority, there's still a lot of gray area, or what I'll refer to as yellow light area. And because of that, it's really important that you analyze your particular fees with your unit's attorney to determine if you need to take any actions with respect to your particular fees. So that's disclaimer number 1. Certainly, we're going to walk you through what we think we know in light of the town of Carthage and other case precedents. But only your attorney will be able to analyze your particular fee structure. The second disclaimer really is about having trouble with this slide here, really is about who might be on the call. There we go. In North Carolina, there are a number of different legal structures or legal entities that are authorized to provide water and sewer services. And as Jeff suggested, many of you have a lot of overlapping authority as to how you're allowed to approach that provision of service. Where there is a key difference, though, between and amongst the different entities is with respect to your fee authority. And that's really what we're going to be talking about today. So I want to make it clear that the majority of our discussion is going to focus on our 2 general purpose governments, municipalities, so cities, towns, and villages, and then counties. And as we said, that's the majority of you who are on this call work for or represent these 2 general purpose entities. I think it's fairly safe to say that most, although not all, of these other legal entities that provide water and sewer services have broader fee authority when it comes to charging upfront fees. And although we'll touch on the nature of that broader authority a bit indirectly,
we're really going to be focusing in on the authority for municipalities and counties in this webinar. So just to get those two disclaimers out of the way, now let's look at what we've got. So some of you on this call may not be all that familiar with the specifics of the Town of Carthage case. You may know that we've had this big impact fee decision from the North Carolina Supreme Court, but you may not know exactly what was at issue or what the court held. And so we're going to spend just a few minutes walking through sort of what was at issue in the Town of Carthage case, and then what the court's holding, exactly what the court's holding was in that case. And then we'll sort of move on from there. So this is really just sort of a summary of two types of fees that the Town of Carthage charged. The Town of Carthage charged a variety of fees for its water and sewer services. I think two of the fees, the water impact fee and the sewer impact fee, we would certainly consider upfront charges. And basically the way these charges were structured is they were fees assessed on developers that were triggered essentially off of final plat approval. The amount of the fee was based on meter size. And according to the ordinances, as you'll see up there, the water impact fee ordinance indicated that the revenue was to be used to cover the cost of expanding the water system, including, as you'll see, elevated storage expansion, transmission mains, etc. Similarly, the sewer impact fee had a statement in which the revenue is going to be used to cover the cost of expanding the sewer systems, and sort of went on a little bit to describe what might be covered in that expansion. And so that's what you had at issue, and those two fees were challenged by developers who had paid those fees, had paid it actually a significant amount in both the water and sewer impact fee, and challenged those fees as being unauthorized, meaning sort of ultra vires or beyond the authority of, in this case, the Town of Carthage to charge. I want to note, because I do think it's significant, that these two fees that Carthage charged were in addition to a tap fee. We'll come back and talk about that in a bit, and also the user fee, the sort of periodic monthly user fee for customers who are actually connected to the water and or sewer system. And so when I talk about Carthage having a variety of fees, that's what I mean. But the court case really was about these two upfront charges, the water impact fee and the sewer impact fee. And so what did the court hold? All right, so the Supreme Court, just a few weeks ago now, invalidated these two fees and basically held that the Town of Carthage does not have statutory authority to charge either the water impact fee or the sewer impact fee, at least as they were being charged by the Town of Carthage. And specifically, I want to point out what the court based its analysis on. And there were several factors to the court's analysis, but I think the most significant factor boiled down to the actual plain language of the municipal and county fee statute itself. So I'm going to present it here for you to see. For those of you who are not aware, for municipalities, this fee language is in 168.314, and although it's hidden there a little bit, for counties, it's 153.8.277. It may just be hidden for me. Hopefully you can see that full screen text. And what those two fee statutes say is that a municipality and or a county may establish and revise from time to time schedules of rents, rates, fees, charges, penalties, very broad, for the use of or the services furnished by any public enterprise. And really what the crux of this decision was about interpreting what does it mean to charge for the use of or the services furnished by. And my guess is if in isolation I asked all of you what does that language mean, we'd get a variety of opinions, particularly from those of you who have been working with utilities for many, many years and sort of understand the nuances of how a system works and gets funded. But for our purposes of the court's analysis, the court actually had something to directly compare this language to, which I think was significant to its holding. And that is that there is rate fee language that applies to several of the other legal entities that we talked about that are authorized to provide water and sewer services. Particularly, the court focused on county water and sewer districts under 162A, although you'll find this similar language in several of the other several of the other local government entities other than municipalities and counties have this similar language as county and water and sewer and districts. And so focus in on what county and water and sewer districts are allowed to charge. Again, revise and collect rates, fees, and other charges and penalties for the use of or the services furnished by, or, and this is the big addition, to be furnished by any sanitary system, etc. All right, so if you're looking at those two statutes and just that portion of those two fee authorities, you'll note the big difference is the addition of the language to be furnished by that applies to county water and sewer districts and also as water and sewer authorities and various other entities, but that does not apply to municipalities and counties. And ultimately, the court's holding in the town of Carthage case was about reading meaning into this distinction. You know, the court said, well, it must mean something that some entities have this additional language. And what the court ultimately decided it meant is that in the town of Carthage, Carthage was not allowed to charge these impact fees essentially at a time where the developers were not connecting or otherwise contracting to connect to the system, and also where the fees were calculated for the purpose of future capital costs. And so I want to emphasize that. I think that there's two elements to what the court focused in on in distinguishing this language and ultimately invalidating the fees at Carthage. One was the timing of when the fee was charged, and the other was the purpose of the fee, or essentially how the fee was calculated. All right, those two things being sort of coextensive for our purposes. So the timing of the fee and also the purpose of the fee or how it was calculated. And in the town of Carthage's case, we're going to go back one here. The court found problematic both elements. The fact that the fee was being charged to developers at the final plat approval stage, and as the court noted, at a stage where it was at least theoretically possible that this development would never connect to the water and sewer system, but also the fact that the purpose of these fees, as stated in the ordinance, were to cover the cost of expanding the water system or to cover the cost of expanding the sewer system, future costs, if you will, not current or past costs. Those are the two sort of, I think, key holdings coming out of the case, this notion of timing and also the purpose or how you calculate the fee. And I want to note as we start to talk about what to read out of the town of Carthage case, how it might apply to other charges that you all are assessing at this point, it may be possible that the court would invalidate a fee even if only one of those problems was present. So even if it was only a timing issue, but perhaps not a calculation issue or a purpose issue, you might still have the case where a court would invalidate that fee and vice versa. So although there were sort of two issues that the court identified with respect to the town of Carthage's impact fees, I'm not sure either, or I think that either issue alone could have invalidated the fee in this case. And so let's go on a little bit more about, I want to touch on one more thing, specifically reading you language from the Carthage case itself, this notion of what it means to charge for the use of or the services furnished by any public enterprise. And according to the court, basically that enabling language allows for the, quote, contemporaneous use of its water and sewer systems, but fails to clearly empower the town to impose impact fees for future services. And that'll become significant as we come back and try to analyze how to apply this holding going forward. This notion of thinking about a charge for the contemporaneous use of the water and sewer system as opposed to a charge for future services. So keep that in mind as we move beyond this and move into the general fee framework and how to apply this holding. All right, so what we're going to do now is actually make that switch. We're going to move beyond sort of what was wrong in the town of Carthage, what the court invalidated in the town of Carthage, and actually try to carve out a framework for what we know is actually allowed. And it's going to be hinged off this notion of what we either know for sure or what we think is a likely interpretation of these two phrases, right? These are the two phrases in the county and municipal fee statute, that you can charge fees for the use of or the services furnished by. And I'll note for those of you who are non-lawyers out there in the audience that you might take the interpretation, well, these things are the same. These phrases mean the same thing. They're just two different ways of saying the same thing. And we might think that I might generally agree with you, but the way courts interpret statutory language is that they're not going to interpret a particular statute as having superfluous language. So it's very likely that a court would say, well, if these two phrases meant exactly the same thing, there would have been no need for the General Assembly to include both the phrases. And so we're going to proceed under, I think, a fairly valid statutory construction approach, which is to assume that these two phrases mean something slightly different, that you have authority to charge for the use of your system, and you also have authority to charge for services furnished by. And so that'll become significant as we get into the specific fees. Before we do that, and I know we keep leading up to it, but before we get there, and this might be a little bit more for our attorneys in the audience, I want to point out that although we now have this Quality Built Homes versus Town of Carthage case from the North Carolina Supreme Court, we actually have a variety of other Supreme Court and Court of Appeals cases that deal with similar fee enabling issues. And so when we look at in a few minutes the contours of what we think your fee authority is, it's not just about what's come out of the case. It's also what's come out of several other Supreme Court cases and a few Court of Appeals cases. Couple quick things I want to point out that you're seeing on the screen. I'm not going to walk through the nuances of each of these cases, but I want to pull out a couple of key points, which I think helps us in our general analysis of what's now authorized and what's unlawful. First thing I want to point out is generally, as you'll note in the Court of Appeals holding in the Town of Spring Hope versus Bissett back in the 80s, is that rate setting under either the city statute or the county statute is a matter for the judgment and discretion of municipal authorities not to be invalidated by the court absent some showing of arbitrary or discriminatory action. I think for those of us who are attorneys reading the Town of Carthage case, we might have been surprised, perhaps disappointed, that the Supreme Court did not start the analysis with this notion. Despite that, despite the lack of this phrase in the Town of Carthage case opinion itself, is this particular notion, and certainly the particular phrasing of this, has been repeated in several of our other fee statutes, and I think still is a valid notion about how a court is going to approach any analysis of whether you have fee authority or not. And so, yes, in the Town of Carthage case, the court found that there was fee authority was lacking. But I think it's important to note that when you're looking at this and analyzing other types of fees, the way the court would actually look at this is to, in some ways, presume validity absent some arbitrary or discriminatory action on your part, which does suggest some broad or relatively wide latitude in setting the fees. The other thing I want to point out is that we do have that language was from the Court of Appeals opinion. That case was affirmed by the Supreme Court, as you'll note in the next bullet point below. And in affirming the case, we do have a Supreme Court opinion that has specifically stated that user fees, so water and sewer user fees that are charged to actual water and sewer customers, can be calculated or have the purpose to include capital costs associated with actual or anticipated growth, as long as those costs are associated with continuing to provide the services to the current customers. And so this notion of, coming out of the Town of the Spring Hope case, is that a unit is free to include in its general user fees a capital component to support future upgrades, future maintenance requirements of that system in order to continue, and even in some cases, I should say, expansion of that system that might be necessary to continue to provide services to those customers. So I think it's important to say, excuse me, important to note that we have Supreme Court precedent that does allow for some future growth, maintenance, and other capital fees Sorry, I need a little bit of water here. Bad allergies today. Some future growth component in those fees. It just may be a matter of who you're charging and when you're charging those fees. The final thing I want to point out is that we do have a couple of cases in which the court has either directly or indirectly upheld tap fees. Sometimes the court refers to them as connection fees. I think a more common phrase is tap fee now, but we certainly have precedent for a town or a county charging tap fees, and we'll go ahead and define what we mean by those tap and connection fees in just a few minutes. But I'm going to leave us here now, leave the precedent alone, although again, I would advise any unit that is looking at their particular fees to read this precedent closely so that you understand your full fee authority. Okay, so for our purposes though, now we're at the point of actually trying to lay out a fee framework for you. And the way I have looked at this is I think it's really important when you get down to the nitty-gritty. Jeff identified some general factors I think are really important. But now we've gotten down to the nitty-gritty of actually looking at a fee structure and what particular fees you can charge. And I think these are the key questions, right? Who can you charge? When can you charge it? And what can you charge? In essence, how can you calculate the charge? And I'm going to add that fourth one. Sometimes it's also going to be important how you spend the money. Before we go forward, I want to focus in on this fourth one because I think the town of Carthage case has led to a lot of confusion on this particular issue. We're going to talk about how there are some situations in which we think that you, or we know that you meaning counties and municipalities, have authority to charge upfront charges that essentially reimburse the local government for past investments. All right, so the government has made an investment in the system and perhaps in extending the infrastructure out. And there's certainly some circumstances in which the government can charge what is essentially an upfront fee to recoup at least the proportional share of that past investment. If that is the case, or in those situations, how you spend the money that you are now charging to that fee to reimburse yourself does not matter. Right? Essentially, you've spent the money and you're now replenishing your funds, and then you're free to spend that money however else you have authority to spend that money. Right? Because that's a reimbursement, money's fungible, you're not tied in any way of spending that reimbursement money for the same purpose for which you collected it. And so I think that's an important point. I'm going to say it again. In situations in which you're charging a fee that essentially reimburses or recoups the cost of prior investments made in order to provide service to this particular property, when the money ultimately comes into your coffers to reimburse you, your government's then free to spend that money however it otherwise has statutory authority to spend money. All right? And there's nothing in the Carthage case that suggests otherwise in that situation. In fact, the issue wasn't even implicated in the Carthage case. There will be other cases, however, and we're going to suggest that we think there are some situations that it's at least possible that you have authority to charge upfront charges that look forward, meaning that you're charging some upfront charges that may encompass some notion of future expenses, estimates of future costs in order to provide the service to this particular property. That is when how you spend the money will become significant. And so in those cases, if you've collected the money for a particular future expenditure necessary to continue to provide service to that property, then you're going to want to make sure you have mechanisms in place that will allow you to actually spend the money that way, whether that be a capital reserve or a restricted fund balance in some way. That money should be considered restricted, if not in the legal sense, certainly in the practical sense, in terms of how you spend it in the future. And so that may help some of you now. I think it will make more sense when we dive into the specific fees we're going to talk about. But I thought it was important enough, given the confusion, to spend a little time up front on. So back to the notion of sometimes it will matter also how you spend the money. Okay, so what's in a name? So as Jeff alluded to earlier, there is a lot of variation out there in what you're calling the fees that you're charging. All right, actually, maybe I'll take us back a couple slides here. You'll note that the fee enabling statute doesn't actually label specific titles for these fees. It just simply gives broad authority to charge rents, rates, fees, charges, penalties for the use of or services furnished by. And so what you label the fee is really up to you. Having said that, to the extent that what you label the fee is kind of a shorthand for how you're calculating it, shorthand for how you're calculating it, who you're charging, when you're charging it, and perhaps how you're spending it, then you might want to be careful in sort of looking specifically at what you're also titling this. But I want to make 2 points, and I'm going to focus in on the phrase impact fee to make this point. I've tried to plot as many ways as I could identify as how you're referring to these fees. Not all of the fees up here are ones that we would consider a substitute for an impact fee, but some are. So this notion of the town of Carthage, the Supreme Court invalidated impact fees that were being charged by Carthage. It is very possible that some of you have fees that you're referring to as capacity fees, recovery fees, system development fees that are also invalid because they're essentially the same thing as what Carthage was charging as an impact fee. So in that way, the label means nothing. I'm going to say that the flip side applies as well, though. To the extent you have labeled a fee an impact fee, that doesn't automatically make it invalid. What makes it invalid is how you've structured, who you've charged it, when you're charging. So it is not the case that every impact fee out there is automatically invalid. You really have to delve into all of those factors, right? You know, sort of going back to when, who, what, where, when, how. This notion of getting into the substance of the fee. Jeff and I talked earlier, and I think he brought it a point. He may emphasize this a little later, but I want to state it up front. There may be some of you who have labeled fees and may not know how you've calculated them. There may just simply have been this notion we have broad fee authority, which I would agree with generally, and you have charged a variety of fees, and you may not know exactly how you've calculated or exactly who's being charged when, and that's where we've cautioned you to sit down with your attorney and do that analysis. And to the extent possible, even if you figure out that what you've been charging based on the fee framework is probably valid or is definitely valid, you may want to go ahead and be more explicit in your customer relations, in your ordinances about how you've calculated who pays this and what the justification is. So Jeff, I think, said it. I'm going to say it. We might come back and say it again. I think that's an important lesson to come out of this case. Okay, so now we're going to get into this notion of red light, green light, yellow light. All right, this is the way we thought of sort of setting the general framework for these fees. You're going to note that what I've done here is I've actually labeled these fees. I've just gotten through saying the label does not matter, but I felt it was important to conceptualize if I put a label on the fee. And I used what I think is the more common label for each of these types of fees and charges. I want to emphasize again, though, it's not about the label. It's about who, what, where, and when. It's about who you're charging, when you're charging the fee, the purpose of the fee, how it's calculated, and in some cases, how you're using the money. All right, so I'm using labels here just for purposes of this webinar, but really focus in on the language under the label. All right, focus in on the structure of what we're talking about here when you're looking at your fees. All right, so what do we know is red line? All right, well, we know one thing for certain now coming out of the town of Carthage case. When you assess a fee on a developer as a condition of development before there's any contractual agreement in place to actually connect to the water or sewer system, and that fee is calculated or has the purpose of funding future capital maintenance and expansion, that's what was invalidated in the town of Carthage case. And so that's what we know for certain is not allowed. Again, whether you call that fee an impact fee, a capacity fee, a development charge, etc. That structure is what was invalidated. Now, of course, there's always an asterisk to everything. So as I said that, what's in the red light area, you'll note below the little asterisk, unless you happen to have local act authority. There are a handful of you out there, and who may or may not be on the call, who have gotten local act authority, mainly in the 1980s, to charge impact fees. And my caution to you there is to work with your attorney and look at that specific enabling legislation to figure out where your red light is and where your green light is. But for those of you who do not have local act authority, I think it's safe to say this is the red light territory. On the other side, I think it is safe to say, based on the case law, and most of it being Supreme Court precedent, North Carolina Supreme Court precedent, there's some things that we know for certain that you can do, sort of the green light category here. Certainly you have authority if there is an issue with new development or existing development, where you either have to expand your system or make investments in your system and or extend infrastructure out in order to serve that property. You may enter into a contractual agreement with that developer or property owner, and part of that contractual agreement may be a promise on the part of the developer or property owner to pay for some or all of the costs associated with expanding that infrastructure and or making changes to the existing system to be able to serve that development or property. All right, so that, I think, a couple keys there. One, it's contractual. Some of you may say, well, this is exactly what we're doing when we charge developers essentially impact fees. We know they're going to connect at some point. This is to recoup the costs necessary to make those connections happen. What I'd say, if that's the case, if that's all that the issue is with your fee, just go ahead and get contracts in place. That's about who you can charge and when, and I think it's pretty clear coming out of the case law that you can't charge before someone's actually either committing to become your customer or actually your customer. And so you can charge this at the development phase, but have it pursuant to a contract with that developer that they are agreeing to connect, and this is part of that agreement. What we also know for certain is that the courts have upheld TAP, or what the courts sometimes refer to as connection fees. And again, the label's not significant here. What's significant is what the courts have upheld, this notion of either being assessed on a developer or an existing property owner when the property actually is connecting to the system. All right, so the notion is this is not at the development phase or halfway through development unless that's the time when the property is actually connected. And there's certainly some cases where the property is not completely developed, but it will be connected to the water or sewer system in order to aid development. And I think it's appropriate to charge this fee as soon as that connection happens. But how we're defining this fee in terms of knowing what we are allowed to charge for sure is a fee calculated to cover just the cost of connecting property to the system. And that can be all of the costs, the meter cost, the tap cost, the boring cost, if you have to cut through pavement, that cost. And Jeff could probably list out all, I don't know if I'm missing some significant connection costs, but he can jump in if I'm missing something. But it's really, when we say what we know for certain, it's about charging those costs that are actually associated with connecting the property to the system. The other thing we know for certain, or the final thing I should say that we know for certain, is this user fee authority. And again, what you label it doesn't matter. What I'm referring to when I'm talking about a user fee is this is the periodic fee that is assessed on water and sewer customers when they're actually customers. Okay, and when they're actually connected, the meter's in, the property is actually connected and available for the water to flow in or the sewer to flow out. That's what I mean by user fee. That's the fee charged when you actually have water or sewer customers. This is where, and I mentioned before that Town of Spring Hope versus Bissett case indicates you have very broad authority. In fact, the broadest authority to set those fees to cover both past investments, current charges, including debt service, and future maintenance, expansion, upgrade costs that might be necessary to serve the property. I'm also going to point out that we do have at least one case, and certainly a statutory indication that that fee can include a profit component. Those of you finance officers out there know that there's a statute, GS 159-13, that allows you essentially to move profit from a water or sewer utility fund to the general fund or to some other fund. I think that statute certainly indicates, and we have one case that is sort of indirectly interpreted that way, that you have authority to set your fees to earn a profit. I think that sort of bolsters this notion that the user fee, you have very broad authority when setting that fee. None of this is suggesting that you have to do that, mind you, but I think this is where you have your broadest authority. Now, so we've talked about the safe zone in some ways, what you're definitely not allowed, and what based on the case law and the plain language of the statutes, you're definitely allowed. Unfortunately, most of you, or I should say many of you, are likely charging fees that fall in sort of the middle. You may very well be charging some of these fees as well, but you might be charging fees in the middle. I'm going to label those fees very broadly as capacity fees. Although, again, it's not about the label, it's about how we define that. And so we do have this yellow light area, if you will, where we just do not know, because we don't have any case law that is directly addressing this issue, we don't know the extent of your authority to charge the fees that might fall in the middle. Having said that, I think we have some notion about what types of what I'll refer to as capacity fees are more likely to be upheld by the courts and what types are less likely to be upheld given the existing case law. And so I'm going to take this yellow area and I'm going to break it up into sort of 3 categories. So I want to be clear about what you're seeing here on the screen. Everything you're seeing now in the middle falls technically into the yellow light area. All right? It's just gradations of the yellow light. So you have some yellow light area that's closer to green, so it's got a kind of that yellow-green. You've got some yellow light area that's closer to the red, so less likely to be upheld. And then you have true yellow light territory, things we really just don't know much about. And so, you know, again, back to the disclaimer, something you're going to have to work with your attorneys and do some risk assessment on if your fees fall in that true middle area. So very quickly, so I hope you're all staying with me here. I know this is a lot, but let's cover what we know for certain and how it compares to this yellow light area. When looking at capacity charges, first thing I want to note is that when I refer to the yellow light area, I'm making an assumption that these charges, anything that I think falls into this yellow light area, are charges when the fee, whatever you call it, is assessed either when the property connects to the system or when you're under contract to connect at some future date. I think if you're charging anything we're going to talk about as a capacity fee, but you're charging it essentially as an impact fee, where you're charging it on new development before there's a contract or before you're actually getting a connection, that's problematic from a timing perspective, no matter how you calculate it. So I want to start with this notion that in order to even get into the yellow area, what I'm talking about are fees that are charged either when the property is connected or when there's some sort of contract in place to connect to the property. And so this could take the form of just simply expanding your tap or connection fee to include these other charges or to include these other cost components, or it could be 2 separate fees that are charged at the time of connection. I don't think that's significant. I think either would work, assuming that you have authority to charge that capacity fee. So when I say capacity fee, and what am I talking about? Again, because you may have different notions of this particular phrase. Well, I think from my conversations with many of you since the impact fee case came down, many of you are charging some sort of fee that attempts to either recapture or reimburse for a prior investment in the system, or capture some notion of what it's going to cost in the future to continue to serve this property, and perhaps to continue to expand the system out to serve other properties. All right, so looking at that most broadly, let's break it down based on these kind of subcategories. Starting with the yellow-green area, what I think is most likely to be upheld by the court, given what we know for certain in the in the sort of green light allowed category. And that's a capacity fee that is calculated either by the equity or system buy-in method, basically as a reimbursement for past investments in the system. This is a true backward-looking fee. So this notion of when you go to tap onto the system, or perhaps when you're contracting as a new developer, you know, kind of committing to connect to the system, that you're buying in to the investment that was already made in order to serve your property, and that you're paying your proportional share of that cost. that was incurred in order to serve your property. All right, I would consider that sort of the safest area. If you've got a capacity fee, you're charging it either at the tap point or when you're under contract, and it's based on this notion of reimbursing or buying in. I think that you've got a really strong argument that this is for charging a fee, and I'm going to make us go all the way back here, charging a fee for the use of the system. This is something we don't actually have a lot of case on, looking at specifically how to interpret for the use of. It strikes me this is exactly what the legislature might have meant when they said that you had authority to charge for the use of a system. This notion of buying in and paying your fair share of the infrastructure necessary to serve you, and then the unit having the authority to, once that service starts, charge for the services that were actually furnished by the system. So I would say that this capacity fee that's calculated based on the equity or buy-in method falls in, sort of fits squarely in your authority to charge for the use of the system. I also think there is a strong argument that if you, at the time someone connects or contracts to connect, that you have known or predictable future maintenance or upgrade costs that are going to be necessary to provide service to the property, that is also something that you likely could fold into your capacity fee or connection fee. And so this notion that, this is actually what was at issue in the Bissett case, the Town of Spring Hope versus Bissett. There you had a water system that by state mandate needed to make these upgrades or improvements in order to continue to function. And so the town knew, in order to continue to provide service, that it needed to make these investments, these future investments. And so it made sense in that case, both practically and also legally from the court's perspective, to say that that wasn't a charge for future service. In essence, it was a charge for current service, and in order to continue to provide that current service in the future. And although that case, as I mentioned before, was really addressing the user fee authority, I think you can make the parallel argument that it would apply at the connect stage, or at least when you're under contract to connect, if you have known or predictable maintenance or upgrade costs. Let me pause there for a second, let you absorb that. Again, I know we're moving through this very quickly, and I want to give time for questions. So a couple more things. I want to move us into sort of the less known territory. I'm going to jump now to the reddish yellow area, what I think is unlikely to pass muster given the case law that we have. And that's this notion of a capacity fee that is calculated solely to cover future expansion costs. So if what you're doing is, what you're looking at is a fee where you say, okay, we've made the past investment, we're not going to charge you for that. Instead, we're going to say, okay, you customer that's now connecting, essentially we're going to charge you to some proportional share of the cost that is then going to allow us to expand out and serve new people in the future. I think that's problematic. And I think that's problematic because you don't have that language to be furnished in your rate statute. I think this is exactly all squares with the impact fee case out of Town of Carthage, this notion of charging for future expansion costs, or at least solely, I should say, for future expansion costs. All right, so that leaves us with this middle area. And unfortunately, I think many of you probably fall in this middle area, the true yellow light area that we really just don't know anything about. And that's this notion of charging the capacity fee at the connection stage or pursuant to a contract, but calculating that fee to cover some measure of reserved capacity either by the combined or hybrid approach, which really includes some component of both existing capacity costs and then planned future capacity costs. And this, as a practical matter, makes a lot of sense, right? You don't want to wait until you run out of capacity completely and then have to start over and charge the next customer an exorbitant rate in order to create the new capacity. And so the notion is that you've got this kind of longer horizon where you're thinking about capacity over some period of time, and that the fees charged for each customer that connects reflect this notion of what we have today in capacity and what we're going to need rolling out in the future. And again, I'd say as a practical matter, that approach makes a lot of sense, which is probably why a lot of you are using it. Whether or not, or how this, how this fits into this fee framework, I don't know. and this is one you're going to have to sit down with your attorneys and do a risk assessment on, and see what kind of justifications you can make for your particular fee structure. I also think it falls into that yellow light area if you're calculating costs, and this is kind of similar around this notion of maybe we're going to have costs in the future, or we certainly know we're going to have costs in the future, but we don't know what they're going to be. Sort of purely speculative nature of future costs. That, I think we just don't know enough from the case law right now to weigh in one way or the other on whether that's authorized under your current fee language. All right, so this is it. This is your fee framework. I wish there was less yellow light area. In some ways, we could give you more certainty about what you're allowed and what you're not allowed to do, although perhaps some of you will be heartened to see that there is this yellow light area that may justify what you're doing or what you would like to do in order to fund upfront costs associated with your system. We're going to obviously have time to answer questions in just a few minutes. Just to close the loop here, though, I thought it would be important to point out that in addition to these fee statutes, the single fee statute essentially for counties and municipalities that we've been talking about, there are other ways to fund water and sewer capital. All right, and this case, the town of Carthage case, had nothing to do with these other mechanisms. And I'm not going to walk through the nuances of each of these mechanisms. This is just to point out there are other options out there that perhaps may become more attractive now that you don't have pure quote-unquote impact fee authority. The only one that I'm going to delve into just for a few minutes is availability fee. And the only reason I'm doing this is another type of fee. It has separate fee authorizing authority, separate from the language we've been looking at so far today. And it's something that gets confused, I think, with the impact fee capacity fee authority, in part because some units of government refer to their impact or capacity fees as availability fees. But in fact, we actually have statutory authority for availability fees. And by statute, they're defined in a very specific way. And these are really fees that are charged where the water and sewer lines already exist within a reasonable distance of property, and they're assessed on property that the unit could mandate connection to the water and sewer lines. But in lieu of mandating that connection, the unit instead charges an availability fee, sort of for the availability of the water and sewer system to that particular property. And you'll note that there are some parameters on what you can charge. This isn't something that you can use to raise lots of funds under, but it's this notion that you can charge the minimum periodic service charge assessed on all utility customers, which is really thought about as the fixed component of the user fee. That's the maximum you can charge any property that falls in this category. I'm not going to waste any more time on this, but I wanted to be sure to highlight that this is different. It is there are separate enabling statutes for availability fees. Okay, with that, I'm going to turn things over to Jeff before we handle questions.
Okay. We do want to point out that we're going to do your best to answer questions in a few minutes, but there are some methods that you can use to answer questions in the future. We at the Environmental Finance Center have a blog. I think some of you are already subscribed to it and saw some of the posts that we've done related to this question and other questions. We're going to give you a chance to subscribe to the blog in a minute. So we're going to pull that up right now. This is a way for you to subscribe to the blog automatically if you are interested in getting future posts related to short research pieces we do on things like pricing. You can go ahead and sign up for that. Okay. The other thing we want to do is just make a quick announcement about an exciting development that we're having in the area of finance in general, and I'll let Kara talk about that.
Yeah, and so some of you may be familiar with the Canon Local Government Law blog, And that's another resource that you have, and certainly we'll continue to update that from a legal perspective on anything that relates to local government utilities. We're launching on Friday, though, a new tool specifically related to finance in North Carolina, essentially a sort of widespreading resource for local government officials related to finance in this state, which will be a combination of a listserv and also a resource for information from the school of government and also our partner organizations related to finance. And so it's hard to do it justice in a very short time frame, but certainly look for that for those of you who are in the finance realm. This is going to be something we're going to be rolling out on Friday.
Great. So we now have some time for questions. I think certainly some of you have been posting questions as we've been going, but if you have additional questions, feel free to type them into the question dialog box. We're going to spend as much time as we can now up until 3:30 answering some of these questions. Some of the questions I'm sure we will not get to or we will not be able to answer, and we will figure out a way to answer the ones we can afterwards and post those answers to all of you subscribed, and then using the other methods we've already talked about, listservs and blogs. So with that, I'm going to act as moderator and ask a few questions, and I'll comment when they fall into more of the finance and engineering side of things. But I think, Kara, there's a couple questions related to if people have fees that may be partially valid and partially invalid. How is that going to work with refunding? And I know we didn't talk a lot about that part of it, and I think there's good reason for that. Do you want to just talk a little bit about that?
Yeah, so I think, again, and I probably sound like a broken record, I think it's really important when looking at any potential past liability for fees that you've been charging, it's really important to sit down with your unit's attorney and figure out what obligation you might have with respect to those past fees. I think we don't know for certain. We're actually waiting on the town of Carthage case. For those of you who don't know, the Supreme Court sent the case back to the Court of Appeals to address a couple of different issues. One was the statute of limitations for, okay, these are invalid fees. How far back is the town of Carthage going to be made to repay the fees? I think in that particular case, there are arguments that there's a 1-year statute of limitation, arguments that there's a 3-year, and arguments that there's a 10-year statute of limitations. And the nuances are sort of too great to get into on this call. But we won't know for certain until we get a resolution from the Court of Appeals and perhaps even from the Supreme Court on that particular issue. So sit down with your attorney, sort of assess the risk. What happens, and to answer Jeff's direct question, what happens if you sit down and you say, okay, yeah, we've been charging these fees, and a portion of these fees seem to fall in the green area, or at least in the yellow-green area, but perhaps a portion of the fees fall into the red area or the yellow-red area. What do you do then? And again, I can't give you specific legal advice for your unit. I think there's going to be a lot that goes into that decision. I will say certainly one approach will be to separate out what the legal component is from the perhaps unauthorized component, and certainly going forward to focus in what's clearly legal or what we think is legal in terms of what you do going forward. In terms of how a court might rule, if that issue were to come up and a court had to squarely address this notion of, well, we've charged a fee and some component arguably is legal and some components not, it's just not clear. I will point out we do have a case, a stormwater fee case coming out of the County of Durham, which involved a similar issue of exceeding the statutory authority to charge stormwater fees, and the court in that case invalidated the entire fee, even though arguably at least a portion of the fee would have been justified by the statutory authority. I don't know how that question was framed in that decision, though, and that could be a very important piece to this. So I don't want to suggest that you may be completely out of hope based on that case law. I think this is a complicated issue, and I guess the most I can say that was a very long-winded way of saying talk to your attorney.
Okay, Tara, I think this is a quicker question, and someone asked if there was a chance that this case could be subject to further appeal.
Okay, so right now we have a Supreme Court opinion on this, on the issue of whether or not Carthage had authority to levy the particular impact fees that they levied, the ones that we've put up on the screen or described earlier. That's done, all right? There's not a further appeal on that particular issue. As I mentioned just a minute ago, though, the Supreme Court, because the Court of Appeals had actually upheld the fees, the Court of Appeals had not addressed some of the other issues raised in the case. For example, the statute of limitations, or whether there might be some equitable arguments dealing with, yes, even though this fee was illegal or unlawful, perhaps there's some equitable arguments that might mitigate what would actually have to be reimbursed. Those are the issues that have now been kicked back to the Court of Appeals and are sort of actively being litigated right now. With respect to whether impact fee authority in this case was authorized or not, that's done. But there are certainly some questions relating to what liability you might have going backwards liability you might have that are still to be resolved.
There's a question that I'll take. Someone asked if water lines have to be physically extended to serve a customer. Is the cost of that extension eligible to be wrapped into a tap or connection fee? And I think Kara and I both believe solid green. So that one you're okay. And this just shows you the range of things that can go into those connection charges. Sometimes it involves setting a meter and putting a few feet of pipe in to hook somebody up, and sometimes it requires boring under a road. Sometimes it requires finishing up a line to the end of a street. All of those costs are required to actually serve the customer, and they are okay. Okay. There's a number of questions that I think get to the need for upgrades that are not dealt with as far, or not required for pure growth. And a couple people wrote in and said that in some cases it's even the state that requires future payment. And we have a regulatory framework in North Carolina that once your system reaches a specific capacity, even if you have some capacity remaining, you have to get started designing and installing future capacity. And I think someone pointed out that that is another argument for always looking forward a few years, 5 or 6 years, and being able to state that those future improvements are necessary to continue to provide service to existing customers and the customers you expect in just the short future. So I don't have a comment, but it is an important factor to point out that in some cases these expansions are actually being driven by regulatory requirements.
We've had a couple of questions. Is there any likelihood or any movement for the legislature to revise these statutes going forward?
So that's a question I can't answer. Because of the role we have as a school of government here, we don't get involved in lobbying efforts, and the General Assembly is out of session right now. I would suspect that there's a number of local governments working with the league, working with the association, looking at what remedies they might have or what they might ask the legislature to modify or perhaps to simply clarify things that are in this yellow area where we think we have the authority or suspect we have it, but just some clarity to make sure. And so I don't know exactly what those efforts are, but I suspect they're happening.
So here's a question related to what constitutes a contract. If a building permit is pulled for a piece of property, will that suffice as a contract, or is there some other type of contract needed?
So at this point, given the case law, I'd be pretty specific. And what I mean by a contract is not rely on an implied contract. actually have, when you're going to have someone agree to connect to your system, whether it be tomorrow or whether it be in 6 months from now with respect to a new development, actually have a contract in place where that person agrees to be connected and pay X fee for that connection in exchange for you, local government, extending the infrastructure or putting in the infrastructure or making any other investments that may be needed to serve that property. So I would certainly recommend you err on the caution of not relying on sort of implicit contracts that might arise out of different situations, but actually go ahead and turn them into actual contracts that deal just with this issue.
There's a question here that if we are a water and sewer authority, are we safe in regards to the fee framework?
It's a great question. So let me back up here. And so I want to be very clear. Right now, all of those who are counties and municipalities, shut your ears, because I don't want to confuse what we just talked about. But for those of you who work for county water and sewer districts, water and sewer authority, our metropolitan districts, you actually have this broader fee authority. All right, and I have the County Water and Sewer District Authority up on the screen now, this notion of being able to charge fees for the use of, services furnished, or to be furnished by. We do have some case law fleshing those concepts out. And what we know for sure, and in particular, I would say you would like to look at the McNeil versus Harnett County case, because that actually involved a county water and sewer district. And then we had a case that came down just last fall in Point South Properties, and for some reason I'm blanking on the rest of the names. Jeff may be able to help me out here. But Point South Properties case that involved a water and sewer district as well. In that case, the court was really looking at the confines of those particular entities' impact fee authority, but certainly assumed that a water and sewer district and these other types of entities have some sort of impact fee authority. And by impact fee authority, again, I mean some sort of authority to charge a property or developer before there's a contract in place, and one that's calculated to fund future capital expansion or maintenance. What we know for sure, though, about that authority is that it does not extend, and this is from the Point South Properties case, it does not extend a situation where the notion of the property eventually connect, where there's just the notion of the property may eventually connect. What the court in that case said is that, and just to remind you of the facts, in that case, the water and sewer district was charging these fees to new development, impact fees to new development, but at that point in time, didn't necessarily have a plan in place to serve all that new development that was being charged a fee. And the court said that just went too far. This notion of charging a fee when there's not even a plan in place to serve that property in the future exceeds even that broad fee authority. But that's all we know. We know you can't charge an impact fee if you've got a situation where there's no concrete plan in place to serve that property eventually. But we do know that you have some authority to charge an impact fee before there's actually a contract in place. And I think, there's your yellow light area. What's in between that? And that, again, I would caution you to talk to your attorneys about that.
There's been several questions related local act authority, and we do have some planning professors that work more in the local act authority that we can try to find the specific list of local governments. Doing research in that area can be very challenging. The authority comes in different years and is in different parts of the statutes. But in my experience, there's been a number of counties that were given that authority in the 80s, and we will try to do some research on that. But that would be something that hopefully your unit of government would know if you had that authority. You likely would have gotten that authority when you were evaluating the possibility of doing impact fees. So, but we will try to answer that.
Yeah, and I will point out that for those of you who are attorneys, kind of to look at this issue, in the town of Carthage case, in I believe the opinion itself lists out several of the entities that had local act authority, but certainly in the briefings by the parties, they went through and sort of cataloged the local act authority. It may not be a complete list, but it was certainly, in my opinion, a good list of the entities out there. Might be a good place to start.
Okay. There is some question related to the authority to enter into contracts. Kara, I don't know if you can comment a little bit about that, the contracts for extensions and those types of things. Where in the statute that might that be, and how is that defined?
Sure. So I think it depends. The answer to this question may, again, depend on who you're trying to contract with and when. There's certainly authority to enter into development agreements with a developer. And that's something that should be fairly familiar to local governments who have new developments. You can enter into a development agreement, and I think you could, as part of that, a development agreement, that contractual agreement, you could actually incorporate this notion of a promise to connect to the system, extend the services, and charge a fee for that connection. You're not limited, though, even in the development scenario, to using the development agreement for that purpose. That's just one tool. The public enterprise statutes themselves give you very, very broad authority to enter into contracts with anyone in order to extend the infrastructure to that property. And we know from the case law that you have authority, unless you've had an annexation, an involuntary annexation. Your board has authority to extend your infrastructure to some areas of the unit and not to others. And you certainly could condition that extension on the property owners requesting it and paying for a portion of that. And at that stage, that's when you would enter into a contractual agreement. If your contractual agreement is with another local government, you may use the interlocal agreement authority. So the question is, I think, almost too nuanced to address. Suffice it to say, you have very broad authority to enter into contracts in this realm. It's just that the particular authority will depend on who you're entering into the contract with.
There's a question that I'll take. Someone asked if funding depreciation in your user fee schedule is affected by this ruling, and in that case the answer is no. Depreciation is seen as basically using up an existing asset, and that clearly falls into the realm of what you are allowed to charge user fees for, the use of an asset. So that's, even though some people might refer to depreciation as a capital charge, it's really seen as using up part of an asset from a pricing perspective. We've gotten quite a bit of. Someone asked a question was, could fees be recuperated fees or fees for a capacity charge that was deemed to be authorized? Could that be transferred to a general fund, or would that have to stay with the water sewer enterprise?
It's a good question. I think there's a complicated answer, unfortunately. I think it depends on how you calculated the capacity fee. So let's assume that what was upheld, what you've done and what would be upheld by the court is this notion of a buy-in method or reimbursement capacity fee. So in the green area of the yellow-green area. In that case, you would essentially be being reimbursed for prior investments. If those prior investments were made with general fund monies, which sometimes they are, you'd be free to reimburse the general fund for those investments. If the prior investments were made using enterprise fund money, essentially other water and sewer money, you would be required to, at least initially, allocate those monies back to the enterprise fund. But then, as I mentioned earlier, if you've got money that exceeds what you need in any given year in your enterprise fund, you generally can transfer that money. And if it's a reimbursement, it wouldn't otherwise be restricted. You could transfer that money to the general fund, so you can do it indirectly. So that's dealing with the sort of buy-in method, reimbursement method. If instead you're charging the hybrid approach or this notion of fees, capacity fees that are tied directly to some future known or unknown maintenance or upgrade associated with the system, those fees I think you should treat as legally restricted. You don't have to put them in the capital reserve account, but you could, or a capital reserve fund, but you could, but they certainly should be considered restricted in the sense that they would stay in the enterprise fund and be used for the purpose for which they were charged.
Looks like we have about 10 more minutes for your questions, so please keep them coming if you have them. I'll just jump in and say we will be sharing the slides with you via email after the webinar ends, and also the recording. And if you know any folks who wanted to be here today and couldn't for whatever reason, we will be sharing the presentation with them as well.
And while we will wait and see if there's some other questions, there's one or two questions that related to a very specific issue that I think we're going to have to try to answer offline. So for those of you that might have a question posted that we haven't answered yet, we will respond to you in one way or another. I'd ask Kara if you have any final thoughts as well after working on this. I know quite a bit for the last few weeks, and I have some ideas too I want to share.
Yeah, so here are my thoughts. I think, well, I've already said so many times, so I'm not going to say talk to your attorney again. Well, I guess I just did, but talk to your attorney. I do think that at least when we talk about this yellow zone and the stuff that falls in the true yellow light or the green yellow light, I think there's broader authority than maybe some of you think there is. And it's really about reassessing when you charge it, who you're charging, and exactly making sure you're calculating it or that your purposes all kind of align. And I think for many of you, that may be all you have to do. And so to the extent that that can help with the panic out there, I'd like to try to do that. I do think that what you have authority to do is perhaps broader than some of you might have thought just looking at the Carthage impact fee case.
From my perspective, I've tried to make sense of a lot of the questions that people have had calling me and been on the phone with quite a few of you walking through your fees. One thing that I have noticed is, and it gets back to the comments I said at the very beginning, is I think there is some inconsistency out there in fee setting in general. We have found several cases where the fees themselves, as they are described in an ordinance and how they appear to be calculated, fit solid in the green category or the greenish yellow category. But then when you see on a web page how a utility is actually trying to communicate these to the public, there may have been some sloppy language. And in some cases, we've seen web pages that say the revenue for these fees are being used for future investments that are needed to serve the utility, yet you don't see that language anywhere in the ordinance or in the method of calculating the fees. So I think that this whole case has caused a lot of people in the water utility pricing arena to review their current prices. And I think that there could be an increase in some of the rigor related to documenting and justifying pricing for these types of upfront fees, but also even for some of the user fees that we have out there. So I think that might be a silver lining in this. And I think some of you, when you actually look and take into consideration some of Kara's guidance, you will see that you might be in better shape than you think, but there may be some inconsistencies that are more of a communication inconsistency than an actual binding legal inconsistency. So that's at least what we hope for some of you. We'll just see if there's one or two last questions, and then we'll wrap it up. Don't think we have anything really coming in. There are some questions related to liability, which again, I think Kara and I are both waiting to see what happens with the case going back to the lower court. There's a question about, will we provide a model ordinance that municipalities could use to comply with Carthage? We don't have that in the works now, and have not done that too often, but that's something we could certainly talk about. There's one question that comes up with a topic that we have not discussed. If a person has a vacant lot, can you charge them if they are not physically connecting?
I think well, so I think there's a couple things at play there. One, you might look at your availability fee authority is actually tied to authority to mandate connections. This is a little bit of a complicated area, so whether you're a county or municipality, if you have, in the case of municipality, developed property, in case of the county improved property that is located within a reasonable distance of your water and sewer lines, and I should add, does not have a valid water well permit, drinking water well permit, you may mandate that those properties connect. And so with respect to completely undeveloped or unimproved property, you may be out of luck. You can't do anything until they actually contract or you get to the point where you can mandate connection. Once you mandate connection, these statutes, although not reflected here, those statutes go on to say you can fix the charges associated with those connections, which presumably puts you back in this area looking at what you can do with respect to connection/capacity charges.
The other way to look at that question is that, again, it's back to what I said about utilities being able to sell water and wastewater treatment, but also selling, in some respects, an allocation or a promise to service. And if that vacant lot the owner wants to go on the market with that vacant lot, and it's being served by a utility that's been in the newspapers of potentially running out of capacity, and the lot owner wants to grab a legal allocation to water, that would be a case where you may want to set a meter. You may want to install a meter box. At a minimum, what you want to do is, if you do collect a connection charge from a vacant lot, is to have very good record keeping and have a contract. Because I think a lot of utilities have gotten into problems on the other side of collecting money for these connection fees and not being able to show evidence that they actually transferred a service. And transferring that service means you also want to deduct it from your available capacity. We've had a number of utilities in the state that had to be very careful with how they allocated capacity and actually kept track of the capacity that was allocated through their agreements. Those type of practices where you can demonstrate that you are keeping track of something, that you are actually selling a service, in this case an allocated capacity that the property owner may need to actually sell their property, I think you're going to be in better shape. That's very different than the Carthage example, where it was very early on and there wasn't a contract as far as we know. So I think that would be okay.
I would agree. I think that falls squarely in this broad authority to do contractual charges.
Okay. We're at the end of the time. I want to thank everyone for being patient with us. I think Kara and I, believe us that we like to answer questions with yes, no. But this has been a challenging topic for us. Hopefully we've provided you with some insight that you didn't already have. We're going to continue to work on this area. For those of you that didn't have your questions answered, look for those questions to be at least acknowledged sometime soon. And for everyone, we will send you out a copy or a link to the actual PowerPoint presentations and the recorded webinar. With that, I think we're all done.
Yes, thank you, everybody. And please, if you have just a couple minutes to give us some feedback on the webinar, that would be very much appreciated. And have a great day.